All right, we're going to look at litigation. One piece of litigation is a caveat, and that is a challenge to the will, which typically goes through the orphans court. You can also challenge irrevocable trust as well. Breaches of fiduciary duties would be in circuit court because anything other than a probate asset is outside the jurisdiction of the probate court. So this chapter really looks at the caveat as one piece of fiduciary litigation. Remember from last class, we looked at the estate administration and sort of thinking about opening the estate and being named as personal representative, filing the inventory and information report, as well as the account. Will caveats. Let's look at the names of the parties. The person bringing the caveat is the caveator. Typically, the person bringing the challenge to the will might be an heir, might be somebody that feels that they were wrongfully left out of the will. Someone that doesn't like the will is the caveator. Who is defending the will? Typically, it's going to be the personal representative, because one of their fiduciary obligations as personal representative is to carry out the wishes of the testator. Standing to challenge a will, which means that you either must be an heir, so that you would take, if there were no will, a beneficiary under a prior will, a trustee under a prior will, but not a personal representative. Okay, so first and foremost in understanding caveats is that not any and everybody can challenge a will. You must have standing to do so. We'll take a look at those two problems. There are various grounds upon which a caveat may be brought. The writing, the signing, and the witnessing, something flawed in the strict compliance with the execution requirements of an attested will. Capacity and insane delusion. The testator lacks capacity, the mental capacity, the legal capacity, remembering that there is a presumption of capacity, so the caveator, the one bringing the challenge, must overcome that presumption. What is the sound mind test, which defines capacity? Does the testator understand what he or she is doing, the effect that it has, the general nature and extent of his property, the objects of his bounty? Does he or she know the family members, and do they know all of those things at the time that the will is executed? Let's take a closer look. Insane delusion. What does that mean? It means that the testator believed in something that no rational person would believe. I think my spouse is from Mars. As a result of that insane delusion, I prepare a will leaving everything to my friend. Insane delusion was recently tested on the February 23 bar exam. Undue influence is a bar exam favorite. Two-part test. Confidential relationship. There must be a relationship based on trust and reliance between the alleged influencer and the testator. And then secondly, a combination of suspicious circumstances. This is a factor test, another exam favorite. You've got a laundry list of factors. Not all of them will apply in every situation, but can you look at the factors and apply your facts and make an argument that there are suspicious circumstances enough to allege that the will is the product of undue influence? Opportunity, unnatural disposition, anything that deviates from heirs leaving property to the housekeeper as opposed to your children. It typically benefits the influencer, and you need a testator who is susceptible to undue influence. If you have a strong-willed testator, then they're not going to be easily influenced, and certainly not unduly influenced. The other ground for a caveat is fraud. There's two types of fraud: fraud in the inducement and fraud in the execution. So fraud in the inducement is, I say sign the attendance sheet, and it's actually your will in which everything comes to me. And secondly, fraud in the execution is you're misled as to the provisions. We'll take a look at the cases in the book, and we will finish up on no caveats.